All right, welcome to This Explainer. Today we are undertaking a really rigorous deep dive into one of the absolute most fascinating and consequential areas of public law, judicial review. Now, this isn't just dry academic legal theory. This is the actual real-world battleground of state power. It's the very arena where constitutional theory becomes practical reality. Over the course of This Explainer, we are going to explore the exact mechanisms by which courts supervise the legality of executive action. Because honestly, if you want to understand how state powers actually kept in check, this is exactly where it happens.
It all begins with this fundamental, kind of provocative question: who watches the watchers? And maybe more importantly, how exactly do courts control the government without accidentally replacing it? It's the ultimate constitutional tightrope. Think about it. The modern administrative state is massive. We're talking about a system that handles everything from education and health provision to immigration and environmental regulation. Logically, public bodies have to operate within the bounds of legality. But on the flip side, the judiciary has to ensure this happens without overstepping its own democratic mandate.
So here is our roadmap for today. 1. Defining judicial review. 2. The grounds of review. 3. Expansion and judicial activism. 4. The constitutional friction. And 5. The modern debate.
Let's kick things off with Section 1, Defining Judicial Review.
The foundation of this entire field rests on a simple Latin phrase, ultra vires. It literally means acting beyond one's legal power or authority. Basically, Parliament grants a very specific power to a government minister, a local authority, or a public agency. If that body steps outside the boundaries of that statutory grant, imagine, say, a local city council suddenly trying to run its own commercial airline, well, they have acted ultra vires, and a court can strike their decision down. This is the primary legal process through which a court examines a public body's decision, action, or even their failure to act.
Now, if you take nothing else away from this, remember this absolute golden rule of administrative law. Courts are solely concerned with the legality of a decision, never its merits. They focus entirely on the process, the powers used, and the fairness of the procedure. They absolutely do not judge whether a policy is politically wise, economically efficient, or just, a good idea. Judges have no expertise and no democratic mandate to make political choices, like setting a local council's budget or directing foreign policy. Their job is strictly supervisory.
Moving right along to Section 2, the grounds of review.
The modern framework for this arrives in 1984 with the landmark GCHQ case. This case is a total cornerstone of public law because Lord Diplock elegantly categorized the exact ways executive action can be legally challenged. Before this ruling, the law was honestly a bit of a piecemeal mess. But this specific case neatly organized the court's supervisory jurisdiction into a clear, usable framework that we still rely on today.
So, Lord Diplock classified the grounds for review into 3 main pillars. First up, illegality. This simply means the decision-maker must properly understand the law that regulates their power and actually give effect to it. So if a council charges a fee for planning advice without the statutory authority to do so, that is illegal. Second is irrationality, often called Wensbury unreasonableness. And listen, the bar here is astronomically high. We are talking about a decision so outrageous in its defiance of logic or accepted moral standards that you'd think the decision-maker had completely taken leave of their senses. And third, procedural impropriety. This covers the rules of natural justice, essentially the rule against bias and the fundamental right to a fair hearing. Grasping these 3 grounds really provides the essential mental framework you need to understand all judicial intervention.
Which brings us to Section 3, Expansion and Judicial Activism.
Judicial review has grown enormously in importance and volume over the decades. Starting back in the 1960s and 70s, we saw a massive growth as courts became increasingly willing to hold the executive to account, effectively sweeping away older, more restrictive doctrines. Then, as we just covered, we got that defining clarity from the 1984 GCHQ case. But a massive structural shift occurred in 1998 with the Human Rights Act, which introduced a new, far more intensive ground of review called proportionality. And finally, jumping ahead to 2022, we actually start to see legislative pushback with the Judicial Review and Courts Act.
Let's talk about proportionality for a second. Established in landmark cases like Bank Malat, this goes much, much deeper than traditional irrationality. It asks 4 really exacting questions. First, is the objective sufficiently important to justify limiting a right? Second, is the measure rationally connected to that objective? Third, could a less intrusive measure have been used? And finally, has a fair balance been struck? This is a highly structured, evaluative framework. It requires the court to conduct a rigorous analysis of the facts, which, as you can probably guess, pushes right up against that sensitive boundary between reviewing legality and reviewing the actual merits of a decision.
Now for Section 4, the constitutional friction.
Scholar Mark Elliott beautifully summarizes the theoretical engine driving this entire area of law. You see, the theoretical base for judicial review is fiercely debated because it sits right at the explosive interface between the supremacy of Parliament and the rule of law. On one side, the traditional ultra-vires theory argues that courts are just enforcing the implied intent of Parliament. On the other side, common law theorists argue that judicial review is actually the court enforcing independent rule of law standards. Ultimately, the intensity of review in any given case reflects a judicial choice about institutional competence. It's about judges deciding when they have the expertise to intervene and when they must, frankly, defer to the democratic mandate of the executive.
And finally, Section 5, the modern debate.
Because of this friction, governments of all stripes have periodically expressed concern about the reach of judicial review. We can see this executive pushback perfectly in the Independent Review of Administrative Law, or IRAL. The government commissioned this review to explore whether the boundaries of judicial review should be explicitly codified in statute. It represents a massive political effort to examine and potentially restrict the reach of the courts. The core concern from the executive branch here is that judicial review has gradually expanded from checking procedural legality into aggressively attacking unfavorable policy decisions.
This political momentum actually culminated in the Judicial Review and Courts Act 2022. A key feature of this legislation was the introduction of an ouster clause. If you're not familiar, an ouster clause is essentially Parliament passing a law that specifically says to the courts, keep out. You cannot review this specific decision. Specifically, the JRCA 2022 removed what was known as the CART Judicial Review, which fundamentally restricted challenges and appeals from the first-tier tribunal from going up to the High Court for supervisory review.
As you can imagine, this has sparked a fierce, highly politically charged debate. The government's argument is heavily focused on resources. They argue that ousting these reviews improves court efficiency by removing redundant, low-success rate appeals, ultimately saving taxpayer money and valuable tribunal time. On the other side, critics argue that this explicitly undermines procedural justice and the rule of law. By removing the High Court's supervisory oversight, they argue it allows legal errors in lower tribunals to just go unchecked, denying individuals fundamental access to justice. It really is a perfect modern encapsulation of the tension between executive efficiency and legal accountability.
So, as we wrap up this explainer, I want to leave you with a profound question to chew on. Has judicial review evolved from a strict mechanism for ensuring legality into a tool for substantive policy review? Do the grounds of illegality, irrationality, and proportionality still provide a meaningful separation between law and politics, or are the courts now stepping into the shoes of the government? Understanding this delicate, shifting balance is absolutely the key to understanding modern state power. Thank you so much for joining me for this deep dive into public law.